the biggest mass killings by a lone gunman in the world at the time, and we did not have a coronial inquest. Our Prime Minister at the time, John Howard, quashed the inquest. He overstepped his jurisdiction, and as a result, we didn't have a coronial inquest into this major crime in Australian history. Welcome to the Wasp Files. Some of this material may be distressing, and viewer discretion is advised. There are a ton of unresolved questions and issues surrounding this crime. This was a major event in Australian history, and I can't stress that strongly enough. At the time, this was the biggest mass shooting by a lone gunman in the world. And rather than happen in America, it happened in a sleepy little part of Australia on a sunny Sunday afternoon in Tasmania at a tourist spot. So, with events, generally speaking, they're explored in great detail, and if there's legal cases, they're brought before the courts, the evidence is submitted, witnesses are called forth, and there is a thorough examination of the event, which is designed to determine the guilt of any guilty parties and to investigate what went on, why it happened, and then to put it to rest. And that didn't happen with Port Arthur. The salient issues with Port Arthur are that, firstly, as I stated, this was one of the biggest mass killings by a lone gunman in the world at the time, and we did not have a coronial inquest. Now, by state law, when any foreigners die on Australian soil, or if people die in a fire or die by violent death, all of which happened at Port Arthur, state law decrees that there must be a coronial inquest. Our Prime Minister at the time, John Howard, quashed the inquest. He overstepped his jurisdiction, and as a result, we didn't have a coronial inquest into this major crime in Australian history. The coroner at the time, the state coroner in Tasmania, Ian Madison, commenced a coronial inquest, but he ceased that inquest, and a letter that he wrote stated that he could not continue to do so because his findings may be in contradiction with those of the Supreme Court of Tasmania. So that says that basically he didn't wish to continue a coronial inquest because there was a possibility that his findings may contradict those of the Supreme Court, which is an odd statement to make. As a result, we did not have a coronial inquest, which by law we should have. As a result of that, there was no in-depth, thorough public examination of the event to find out the causes, the motives, what happened, why, who was involved, and the outcomes. The second aspect is that we didn't have an open trial. The reasons for that are that the perpetrator, Martin Bryant, who was convicted and sentenced as a result of the crime, pled guilty. So once you plead guilty in a criminal trial, they don't have to present evidence, so it's case closed, throw him in jail, lock him up and throw away the key, which is what occurred. The only issue with that is that as a result of that, the vast ton of evidence that was collected about the Port Arthur massacre, and the Tasmanian police did conduct an intensive task force to examine all aspects of the crime. So that includes the forensics, the ballistics, witness statements, all of that. A lot of that did not have to be tendered in court. There was a comprehensive interview with Martin Bryant that was read out at a pre-trial hearing, 65 pages of which were redacted. And some of the material in the unredacted form, which I'll provide as evidence, question the propriety of that case. So just to summarise, We didn't have a coronial inquest. There was no open trial. So a lot of witnesses and a lot of people who had differences of what they experienced at Port Arthur were never called to give evidence in a court of law. Vital ballistic evidence, DNA, fingerprints were also not tendered, as were the records for the historical origins of the firearms that were used in the crime, amongst a ton of other material that never saw the light of day. So all that did was leave a vast amount of unresolved questions and issues, witness statements that didn't add up, people that had positively who knew Martin Bryant that didn't identify him as the shooter on the day and made witness statements in relation to that. And these were quashed. They were never heard in court. In regards to Martin's confession, the only thing to say about that is that Martin, who was diagnosed as having an IQ of 66, which makes him the equivalent of a young child, was put on a guardianship order in 1993 by the same Supreme Court in Hobart. Now, that dictates that he was not mentally capable to be able to handle his own affairs. So he should not really have been able to enter a plea in the first instance of guilty or not guilty. Despite that, Martin Bryant, once he was incarcerated at Risdon, held a not guilty plea staunchly for 5 months. He was kept in solitary confinement. By his own admission in his interview, which was redacted from the pre-trial hearing, he was tortured. He said, quote, "They pulled my arms up behind my head and they made me lie down on my burnt back," because Martin was burnt in the Seascape fire. Now, that was not read out in court. If that had been, a prosecution and a defence would have been in very shaky territory about the legitimacy of that record. Martin held his not guilty plea for 5 months, and his defence lawyer, John Avery, who was later on disgraced and sentenced for misappropriating his client's funds, he went to jail. Martin's defence lawyer, after 5 months, went to his mother, Carleen, and said, "You have to help me to get Martin to change his plea to guilty." Carleen, his mother, and she wrote this in her book, My Story, which is freely available, went to the prison with John Avery and told Martin that unless he changed his plea to guilty, he would never see her or his sister Lindy again. So Martin changed his plea to guilty. So that doesn't mean that he wasn't guilty, but it certainly casts some aspersions on that plea because he was basically threatened with being cut off from his family. As a result of not having an open trial, and also the fact that Martin has been thrown in jail and very, very few people get to interview Martin Bryant. We haven't heard from the horse's mouth, so to speak. He was never put on trial. He was never cross-examined. He's never been video interviewed. He was videoed interviewed at one instance by 2 inspectors. This is 5 months after he'd been held in solitary confinement. And at that point, he hadn't even been charged with the full extent of his crimes. So when they basically charged him with the deaths of 35 people, his reaction was stunned. He had no concept that he had killed that many people or was charged with their murders. So taking all of that into account, and also once you do the deep research into Port Arthur that I have, there is an enormous amount, a dirge of information that is contradictory to the mainstream story and that has made people uncomfortable with the mainstream story as it's been produced. People want answers. They want to know why these events occurred, and they want to know why the information has been quashed. In summary, too, in 1996, at the pre-trial hearing, the Supreme Court ordered a ban on the evidence being released for 30 years. This was due to be released next year in 2026, in which case the supposed evidence of the case would have been presented to the public, supposedly for examination, public examination. However, after I announced that I was going to make a film in 2016 about the Port Arthur massacre, TAHO, which is the Tasmanian Archives and Heritage Office, had a video conference in which they stated that they were going to digitise all of the files of Port Arthur, the audiovisual material, the files, the task force material, and place them in the archives under the highest restrictive category, E75, Chief Police Commissioner's eyes only, for a further 75 years. That means you, me, and everyone associated with Port Arthur will be dead before that information is released. So the reason Port Arthur won't lie still is because the information has been repressed unjustifiably, in my opinion, and that there are far too many questions that people have no answers for. Some of these are the victims, people that I know personally, and survivors who are angry about the way they were treated, who were never given their say in court, who were shunted to the side, who were never interviewed by the media. And these people have very different opinions about Port Arthur. Thank you for joining us for this episode of the Wasp Files. Feel free to share far and wide and see the attached files in support of the episode. Thank you.